That's why I agree. And yes, their aspiration work is a claim adjuster in the field of workers' compensation or a third-party workers' comp administrator and a summary. Graduated from to a law. During the studies at Harvard School of Law, is a member of the Judge College. Answer Jennifer's job.
Baby. If the clicker's working. That's the Zoom. Hold on. Oh, I want to. Yep. Got it.
That was you trying to get a nice Tracy.
Well, he did it. I'll pay very close attention. Got to get to the right screen. I'm running multiple screens of error. All right, where are we? Should. There, nope, too many. Zero it.
Steps down from his bunk and his foot lands into a crock pot full of hot water. Now, I don't know the answer to this question, but what was the crock pot of hot water doing at the foot of the bed? That is never in there. That's the question I really want to know. Anyhow, he suffers burns to his foot. The employer initially denies it, says it's not anything to do with his job. The crock pot had nothing to do with his job. Getting up out of the bed is an everyday activity, doesn't have anything to do with the job. And so the court, next slide, the court looked at this one and said, no, it in fact is compensable because he was told by his supervisor that he had to sleep in that truck. He was awoken by his supervisor, which
and they,
think he would know. Well, he should have known it was there, but again, I don't know that that's enough to take it out. Just interesting. I don't know why anybody would have a crock pot full of hot water in a sleeper cab. If you've ever been in there, they're tight. You're bound to step in. But anyway, yeah, it'd probably go over here too.
focusing on the crock pot, can anybody think of any issues that the crock pot would create? Yes, ma'am.
Which would absolutely make it compensable here, because those are the basic needs that people have, and so if that's part of it, that's going to be, again, furthering the interest of the employer, because they're, you have your basic needs.
Now take the same scenario and take the truck away, and let's say he's at home, same situation. He's at home in his bed, his crock pot at the foot of his bed. The supervisor calls him and says, get up and get to work. We got a different scenario there? I think so. I think one of the key issues in this one is where he was and why he was where he was. He was in the company truck, or is in his truck at the company's direction, and you are to sleep here. And I think that small facts can make a big difference in a case. Next one. Table for one. Next slide. It's an Indiana case. Very large university employee, not the university is large, the employer is large. Diabetes, knee injuries, acquired a cane, got stuck in a cafeteria table. Why was she there? It was an employee appreciation dinner in a cafeteria. Sitting there eating, tried to get up, and apparently it hit the buffet one too many times, could not get up. Got stuck and kind of sad. Broke her leg as she tried to get out. Indiana initially, the employer and the initial court denied the claim and said, simply getting up out of a table where you're eating is personal in nature. Next. Went to the appeals court, and the appeals court disagreed, said it is compensable. And even though her personal condition contributed to the accident, it was in some part due to the employer provided table, and it was an employer event. So again, this was an employee cafeteria, and it was an employer sponsored and required event to get up. So again, it kind of goes back to the other cases where you're looking at, why was the person where they were and what were they required to do? In Alabama?
Y'all, we take these folks as we get them. This pre-existing stuff always comes up in the majority of our cases. We're looking back at pre-existing, but she, although she may have been a mess, we hired a mess, and so did it arise out of the course of employment? Yeah, I think so. It's employee appreciation dinner. So yeah, that's probably in the course of employment. Did it benefit the employer? That's another thing we're going to look at. Again, I'm going to say yes. Especially in today's market, good employees, we want to keep them. And we're going to do things like have benefit, those kind of dinners and things of that nature to keep our employees happy, because we want to keep them there. So it's to our benefit that she would be at this event. Maybe is it mandatory? Is it not mandatory? I don't know. I don't know that I would necessarily get so hung up on that, because in the end, it's still kind of to our benefit to keep our employees happy and have them at our things that we're sponsoring. So there are probably some other things that we would want to know about it, but just basically from what Mike was talking about, yeah, I think we're.
And again, one of the issues that Jack talked about was the event mandatory or not? And we'll see another case in a little while that when you determine whether an event is mandatory, you really got to look at it. It doesn't have to actually use the words mandatory, but what are the circumstances? Does the employee feel like they need to be there? Take the company softball game, for example. Is it mandatory to be at the company softball team? Well, if you're one that hits dingers over the fence every game, versus the guy that strikes out every game, that may be a different sort of mandatory. So I think you do need to look at that a little bit. And again, what was she doing at the specific time she was getting up? Was she accepting an award? Was she accepting some sort of accolades? Was she to get up and give applause to her boss? What was she doing at the specific time that she got hurt? I think those are all little things to look at in a situation like this. And I think this is one of those that if you all were to call us and give us the simple facts that I just gave you, we'd have a litany of list of facts that we would want back from y'all, because this is one of those I think could really go, at least here, could go either way. Next one. Doggone it. This is an Oregon case, and it is a work at home case, which is something everybody's dealing with, has been dealing with for at least the past 2 years. And this is becoming a more and more common situation. This actually is an older case, but is a J.C. Penney's decorator who is going to get, she worked at home and was going to get fabrics out of her garage, which was actually detached from her house. As she's going out there, she trips over her dog. And falls down, breaks her wrist. The J.C. Penney's initially said, is denied. This is your dog. It's got nothing to do with work. I don't care that you were working at home, and I don't care what you were getting. Certainly, the risk of tripping over your dog is something you created and has nothing to do with work. They also said they took the position, and again, you got to consider the timing of this. They took the position that the home was outside the employer's control, and therefore we're denying whatever happens at your house. That's your problem. You're not at the office. Next slide. The appellate court did find it compensable and said the home, in fact, is the workplace in this situation, and therefore all home hazards became work hazards, including the dog. Again, realize the timing of this is pre-COVID. So they were both the employer and the courts were dealing for virtually the first time of how do we deal with people that work at home. Alabama.
Excuse me. I'm a little bit on the fence on this one, mainly because,
because you have cats.
Because I have lots of cats and they will make me fall.
But uh, we're going to have to watch these at-home cases. Now that we've got so many people working at home, we're going to have to watch the trends of the courts on these to see what they're going to do. My gut in this is the dog. That's going to throw it off. Fido is, that's really outside of anything that the employer has to do with, and they certainly cannot control the dog. So that would probably make it non-compensable here. Now, just because, don't get hung up on dogs, because there's a lot of cases where you're going to see like the mailman getting chased by a dog or bit by a dog. Well, yeah, that's compensable. So it's not just but so again, we're just going to have to kind of watch this to watch the trends of the court to see whether or not that's actually course of employment. Kind of, hung up on it's an obstacle. What if she tripped on something else? Would that change this? Possibly. So,
has anybody had issues with interesting cases or with work at home yet, where you've had to deal with situations that are a little strange like this? I think, Jack pointed out some other issues with the dog, and obviously that's the key in this case that makes it different from, I think, what we'd all say in another case. She tripped over the cord to her laptop. I think everybody would kind of agree, hey, that's something work related. That's foreseeable that would be it. The dog creates another issue. But what is a situation where your employee has dogs in the house? That's, you've been over to their house. You know these dogs. You knew that going in before you said the employee could work at home. Those kind of things may sway a court a different way. And again, like Jack said, as we go more and more into these work at home situations, the courts may or may not expand what they believe or what they see as a work related issue or risk in the home. And obviously, this court was very strict in saying whatever was in the house was going to be covered. Next one. Next slide. Oddly, this is a Utah case, and I say oddly, if familiar with the general population of Utah, this is not what you would expect to be going on there. This is an employee that was on light duty, secondary to a previous workers' compensation accident. They were on light duty and paid some wages and benefits before their accident. While they're on light duty, the employee was fired for sending pornographic images to a coworker's cell phones. Again, this is Utah. Not that it can't happen in Utah, but so the court said the employer owes TTD and that the employee intended to and was working light duty at the time. They're not working light duty now only because they were fired by the employer. So the employee did not intend not to work light duty. So therefore they're entitled to TTD. Alabama.
nope, I don't think so. The employee or the employer had the light duty. If he wouldn't have been messing up, he could have got his light duty in. The appellate courts in Alabama, the good state of Alabama, we don't like ugly, and they're not gonna let that reason for termination go unnoticed. They're not gonna give him any money on that.
What's important in cases like this, when we get these calls a lot of times where somebody is terminated, and then the question becomes, are they entitled to TTD or TPD when they've been terminated? And the ultimate question is, had they not been terminated, what would have been the circumstances? And that's sort of the situation we're talking about here. Did the employer have light duty or some sort of restricted duty available to that employee but for the termination? If that's the case, then they're not entitled to TTD during that or TPD during that period of time. It's important though to make sure that is if you're the adjuster or you're the lawyer in the case, make sure that is an accurate statement and that's true. If you're familiar with that employer, you probably know whether or not that's a true statement. And it's not just a statement being made for this particular case at this particular time, because that can get you in trouble. You know, red flags go up when you've got somebody terminated with a pending comp claim. So you've got to be a little more careful. But if that is a policy that they have, you know, some employers have policies that no matter what, we're going to put you back to work. And those are the easy ones, because then you can say, well, you know, had you not been terminated for your email activities, then you'd be working light duty. And I've added in here, what about wrongful termination? Again, that's a concern everybody has. I feel pretty comfortable defending that one if these were the facts of why the person was terminated, whether they had a comp claim or did not have a comp claim. All right, my clicker works. Quit clowning around. You might have noticed a clown theme in this. Obviously, this is a circus theme here, but more importantly, Jack Rogers is deathly afraid of clowns. And since I got to do the PowerPoint presentation, I put a few clowns in here.
Yeah, I was pleasantly surprised to see all those clowns.
That's why you don't give your law partner the PowerPoint in advance. This is a Pennsylvania case. Again, we got another employee that is on light duty. The employer said, no, you're going to work full duty. The employee, through his attorney, said, no, my doctor has restrictions and I'm supposed to be on light duty. The employee received a termination letter from the employer. This is all good, great facts for the defense. The employee, after getting the termination letter from the employer, had a heart attack. It was alleged that the heart attack stemmed from being fired. The initial ALJ or Workers' Comp Committee denied the claim. It was upheld by the appellate court, saying there's no causal connection between the termination and the heart attack, which actually was 2 days later. Thought it was interesting that they didn't say specifically that a heart attack and being terminated was not going to be a link. It was just the fact that it was 2 days later. They had a big deal about the fact that he obviously wasn't that upset if he didn't die for 2 days. In Alabama,
I think Alabama's it's no. They're not going to accept that one either. Just like number one, like Mike was saying, I don't think they're going to relate the letter and the heart attack. But even you add the 2 days to it, no, they're certainly not. My biggest concern with this would be the wrongful termination part that the employer is going to get into. It's one, to me, it's one of those, y'all don't throw the baby out with the bathwater. You know, they were looking at paying a little bit of TTD on this case, but now they've really exposed themselves to a bad wrongful termination case, and that's where the money is on this.
obviously nobody in here has an insured or is an employer that would do something like firing somebody after they were told by their employer that they weren't supposed to be on full duty. I added in here too, an interesting twist I think to this too is the letter. Let's go back to, let's assume that he actually got the letter and immediately died of a heart attack and the 2-day thing was not an issue. There becomes the question is the letter, is receipt of a letter a work activity? Is that part of your job? You got the letter at home through the mail, those are additional questions that you want to kind of look at. Is that part of the job? Or is it different if you were at the job and your employer handed you the termination letter, you're actually on the property and you drop dead of a heart attack because you got the termination letter? Again, little facts can make little differences, or big differences rather. This is one some of us can relate to today, hungover. Hang on. This is we're back to Pennsylvania again. This is a liquor store employee who is robbed at gunpoint and then claims he's got PTSD as a result of the robbery. Pennsylvania's law is a little different than ours. In order to recover for a psych injury, you've got to show that the problems are not a subjective reaction to normal working conditions. So, in other words, my boss was mean to me today. In Pennsylvania is not going to get you a emotional distress or PTSD or something like that type of claim. It's got to be something a little more real. And in Pennsylvania, even though we can all argue that PTSD is in fact something you would get from a liquor store. They said that no, liquor store robberies is a normal work condition. You expect that to happen. And in this particular area, this had 4 same robberies within the weeks preceding and 100 in the 9 years in the same area. So they said in this particular area, and I'm assuming this is, Pittsburgh, Philly, something like that in a big city, that this was something that everybody should expect. In Alabama?
No. Alabama, we're a little bit different. You can certainly have psychological injury in Alabama, but you've got to have physical injury first. Where's the blood on this? If she'd have had even if the employee would have even had the smallest of injuries, then a claim could be made for compensability on that. Say that they were running away from the robber and bumped their knee or twisted their knee or something like that, then they might could pull that in. But if you're just, ooh, it scared me, then you're not going to get it.
And again, it doesn't matter how slight the injury is. There's got to be an injury in Alabama in order to claim emotional injury as well. Buzzer beater. Sorry for you LeBron fans. This is an Illinois case. Middle school teacher is involved in a student and teacher basketball game. Breaking his arm, going up for a layup. He's a science teacher. No offense, just saying it's a science teacher. And we talked about this earlier, the voluntary or involuntary nature of an activity from the employer. The game was a voluntary game. However, this guy was apparently fairly decent, and the principal had asked him over and over again about whether he was going to play or not. In addition, the employee was facing his performance review in the coming weeks, which would have been conducted by the principal who was asking him to play in the game. However, the Illinois initial courts denied the claim, saying it was voluntary status and therefore is not work-related. The appellate court, however, looked at the term voluntary and looked at the actual facts of it. Yes, it was a voluntary game, but the guy was pressured by the principal to play in the game. He was concerned about his performance review, and then the teachers that were performing in the game, were playing in the game, also had duties as teachers with regard to the students that were playing on the other team. So they said, in fact, this is work-related and it was compensable.
Excuse me, Alabama, I think is going to go the same way. Going to look at it just like that. And it's pretty, voluntary. Yeah, that more than likely is not necessarily voluntary if you're getting out there doing something with those kids. If you're a teacher or what have you, so they're going to take all the different elements of it and put it together, and it's probably going to come down as compensable, just like this one.
Next one, gunning for him. It's a Maryland case, and hang with me. The facts get a little hairy here. We've got a hotel employee who's the claimant, got into an argument with his coworker over some supply carts that were being used for a banquet at a hotel. The argument got to the point where the coworker called a friend over and said, "I want you to go get that thing and take care of the employee." The friend complied, and the two got into a fight, that being the friend and the employee claimant. Supervisor intervened and told the employee to clock out and go home. Not deterred by any of this, the friend pursued. The friend is the one who went to get the thing and take care of the situation. Pursued the employee claimant for 13 miles in a high-speed chase, culminating with the friend shooting the claimant. We got all that? I'm not sure I did. But the court in Maryland said it is not compensable. Despite that the initial confrontation and argument between the employees was on the premises of the employer and involved an issue related to the employment. Remember, this was over carts being used in the banquet. The actual assault, which occurred 13 miles later after a high-speed chase, did not arise out of employment. They also, interesting, used the coming and going rule to deny the claim. And as y'all know, there's a coming and going exception to an employment related claim. If you're coming and going to the employment, generally that is not a covered act under workers' compensation. They actually use this, saying that when the high-speed chase occurred, he was going at that point. Alabama.
This is a tough one to me. You know, I expect Alabama to use the same analysis as the Maryland court did, but there's other elements with this case. You know, let's take it up a little, you know, swap it around a little bit and think about, you know, what if it had happened, the shooting on the employer's premises? We've got to remember this is arising out of employment, because what started the fuss was what they were, you know, hired to do. So, you know, if it occurred on the employer premises, I think you would really have to look at this one hard, even if it was the hired gun. It arose out of the employment. You know, and then if you take it even a little further, and let's say that the chase actually occurred, but this time it was the co-employee. Would that make it compensable? I don't know. I mean, it's still the same fight. These two co-employees started fighting about the job, and they carried it off the premises. They're going to look at that one hard. Years ago, I had a case that kind of similar to this, but not exactly. It was actually, and some of y'all may know this, some of you may not, but they're within the agricultural industry with all the chicken houses. There are groups of people who their job is to catch chickens. These guys are amazing. They can, they'll come in on a bus at night, go in there and catch that house of chickens in no time whatsoever. Well, I had a stabbing occur out of that, and it was two guys, and they were fussing about one of them wasn't pulling their weight and catching chickens in the way that they should catch those chickens. And one of them cut the other one, and cut him pretty good too. And it was a compensable case because they were fighting about the catching of the chickens. So, you know, these are just, you got to take the elements as they are and lay them out.
And I think, you know, in an analysis like this, the first thing you want to look at is why did the fight ensue? That's all that's the underlying important thing. If the fight ensued, the very beginning of the fight had nothing to do with work. In other words, it was about one of them's girlfriend or something like that. It had nothing to do with work. Then that really ends the analysis. Whatever occurred after that is not going to be found to be compensable. Again, in this particular situation, it was work related, the initial fight. So then you got to keep going down the line. Nightmare of a claim. It's the Arkansas case again, and very similar to the last Arkansas case, which was the one with the truck driver, if you'll remember. This is a firefighter who works 24-hour shifts, and he stays at the station during his shifts. He sleeps in the quarters at the station, which are provided obviously by the employer. The middle of the night, this employee wakes up from a nightmare where he had a dream where spiders were crawling over him. He jumps out of his bed and fractures his foot. It's initially denied as idiopathic. The courts get it, both the lower court and the appellate court, and the employee failed to prove that the accident was arising out in course of the employment. That one makes a whole lot of sense to me. Go get Alabama, and then I think we're about out of time.
You're right.
All right.
Oh, goodness.
Do an Alabama one real quick.
Well, my, you know, it could go either way here. I don't know that our courts would necessarily agree with Arkansas. You got the facts, the key, you know, is the employee required to be there? Yep. Did the employer provide these accommodations? Yep. Did the employer benefit from him being there? Yep. So, you know, I think it's something that when you got somebody living there, you're going to have some increased risk as far as compensability of claims. And so this could fall within that line that possibly compensable. Don't know.
Sorry, we're out of time. I'll cut a little bit short, but thank y'all. Appreciate it.
Thank you.
presentation is entitled When to Move Before Jurisdiction Gets You Deep Fried. I think if you've been in the meetings yesterday and today, you're going to remember, especially you out-of-state adjusters, that jurisdiction matters. How are you?
I'm good. Hey.
Good. That's Jamie.